All right, welcome everybody to Holmquist and Gardner's quarterly fourth quarter webinar on Seattle and Washington State employment law. Very excited to be celebrating our 15th anniversary this year. You can see the cool logo in your next to our logo. This is the end of that 15th year anniversary celebration. We started off the year, our quarterly webinar was on FinCEN filing, the fun of the BOIR reporting that everyone's got to do now. Subject to a recent injunction and we don't talk about, but the Q2 webinar was on when to update your estate plan and why and what to look out for. Q3 webinar was an update on Washington eviction law, unlawful detainer, commercial and real estate, residential evictions. And today, super excited to have on a dear friend and colleague of nearly 2 decades, Aaron Rock. Before I get to the intro of him, give you the normal precursors to our webinars. Next slide, please, Joe Bell. We're going to be talking about a lot of different things today, and those are not substitutes for actual legal advice. You will need to retain your own counsel if you want actual guidance. We're here to bring some information to the table and give some updates that we think are very helpful, but they are not a substitute for actual legal advice. Holmquist and Gardner is a 10-attorney firm practicing in real estate and business law. I head the transactions team. Hamilton Gardner heads the litigation team. And we have an estate planning team under our transactions team. So doing a lot of taxable estates and probates should you need those services. In 2008, some great things happened. There was an economic collapse in the real estate market, and 2 great firms were formed, one of which was Rock Law in February of 2008, and in November of 2008, Holmquist and Gardner was founded. Right in December of 2008, we think, we did a great lunch with Hamilton and I and Aaron, and we talked about the travails of starting a firm. Aaron graduated from law school quite a few years ahead of us in 2001, came out of law school, worked at Carney Badley, an established firm, and started his own shop. Since then, while we operate in a general counsel capacity and certainly have handled employment issues from time to time, whenever we come up with anything nearly complex or needing extra assistance, Aaron has been the rock upon which we have leaned. And he has skillfully assisted our clients through any number of disputes or transactions or terminations. And so find it an extreme privilege to have him on with us today to give us an update. Aaron, thank you for joining us and giving us a few minutes of your time today.
Hey, I appreciate the invitation. And I'd love to talk with folks about employment law. And I've appreciated you and I have had a chance to talk about not only running the business, but then how to lead and manage the business. And you've always had great insight. And so, again, I appreciate the chance to talk to your stakeholders.
Yeah, so, and I see a lot of names here on the attendee list. I'll just mention that this has been one of our most popular webinars over the past 2 years, and sign up. So as anyone that's in attendance here, just note it's being recorded, so it'll be on our YouTube channel, and you can, to the extent you hear some golden nuggets, which I'm sure you will, feel free to share the link that gets emailed to you with your colleagues so that they can benefit from the magic that is Aaron Rock as well.
Thank you.
So with that, I think we'll get right into it. Today, we're going to talk about 4 main topics. And by we, I mean Aaron, and I'll interject some things that are happening in our world and some questions. We're going to talk about recent Seattle and Washington employment law updates. We're going to talk about whether non-compete agreements are still enforceable in Washington and how and when and why. We're going to talk about the best practices for terminating employees and cannabis at work. And when we cover these topics, we're focused on sort of the updates and kind of what's going on in that sector right now. This is not intended to be everything in the world on this. I know that Aaron is an adjunct professor, so he can teach for hours on any one of these topics. He's going to give us some snippets. And if you have questions while we go through this, feel free to type them into the chat. We'll try to get to them as they come up or deal with them at the end. And as always, if there are questions, our email addresses will be here. So with that, I'll turn it over to you, Aaron.
Thanks, Imans. So some changes. What's coming for what's happened recently? What do we expect to see in 2025? One thing is a lot of minimum pay, not only in by the hour, but salary is raising across the board. And so I've got a slide. I won't read the whole slide to you about minimum wage pay raising, but it's raising at the state level, 16.28 an hour. Uh, Unincorporated King County now has a minimum wage. Seattle will move to $20.76. Uh, and Seattle has had a difference in pay for a few years. They've started they were proud of their first $15 minimum wage raise. And then for a long time there, Seattle differentiated between if the employee got comp through tips, or if the employer offered healthcare plan that made or health insurance that made some minimums, they could pay lower than if you didn't. Those differences have gone away, and so now Seattle just makes raises minimum wage for all hourly employees. There's a statewide minimum salary for exempt employees. And so I hope you understand the term exempt versus non-exempt. Um, the A whole webinar on that if you don't. The short version is if exempt would be exempt from minimum wage requirements. You don't have to pay them overtime. You don't have to make them clock in and out or give them paid rest breaks because they're just paid a salary. The minimum salary threshold for Washington State is raising. It's $69,305.60, and it'll be moving up again over the years. And there's a lot of cities getting in. Bellingham, Burien, Tukwila, Renton, SeaTac also have their minimum wages. But it would be like reading the phone book to you. So let me move on to the next topic.
Thank you for
Um,
that.
Paid sick leave in the headlines. So paid sick leave was in the news recently. The state auditor went in and looked at how the Employment Security Department was managing. You can now get paid family leave, which looks a lot like unemployment. And then you can also get unemployment. And the department was paying people both kinds, even though they're not supposed to double dip. And the auditor came in and said, "Would you please do your job?" And the department said, "No, we were doing it manually." Um, and so if it came to their attention and they felt like it, then they would catch someone from double dealing. Uh, Great government at work. How we're going to fix that? We're going to raise. We gave away $1.2 billion in unemployment insurance, paid family medical leave totaling 1.3 billion. And so how we're going to fix that is we're going to raise the premiums. So every employee pays into this, and then employers, after they reach a threshold, they need to pay a few more percentage points. It's going to go up to 0.92% of the wages, split between the employer and employee. We're going to raise taxes to fund the project to digitize that instead of relying on do it manually. So rates go up, taxes go up, and government gave away a whole bunch of money that we won't get back. In other news, when would a new law be like a beard? We have the Employee Free Choice Act. The Employee Free Choice Act now says you can't require an employee to sit through a meeting or to read your communication if it's about religion or politics. This is this is a beard. This isn't what the law was about at all. Really, what's happening here is the National Labor Relations Board reversed a longstanding ruling. If employees are trying to unionize, the employer can get them in a room and explain to them all the terrible things that the bad consequences if you form a union. Um, and the NLRB said, yes, you can do that now. So Washington State, one of the most union-friendly states, now passed a statute at the state level, and although it's under the guise of no politics or religion, it defines um, telling people the truth about how unions have negative consequences as fitting politics. And so you can no longer have a captive meeting to tell employees the downside of having a union. And you might want to have a new policy, a little paragraph that in your, if you have an employment handbook, you might want to include a disclaimer in there to help you mitigate the risk that somebody says they were required to read your email or sit in a meeting and somebody said something about religion or politics.
So we did get a couple questions that might be good to tap into right now. First question was, can employers ask an exempt salary earner to clock in?
Can you ask an exempt salary worker to clock in? Yes. Yes, you can. We're not going to change their pay depending on how many hours they work. Because if you do, you're threatening the exemption. But you can have them clock in and clock out. I don't know what you're going to do with that, other than demonstrate that they were on the job.
And then does the Washington minimum salary have a downward adjustment for rural areas?
Great question. No. And this is auto adjusted. It'll automatically increase. It's tied to the consumer price index, and so it'll keep going up. Maybe someday we'll look at whether there's a relationship between raising minimum wages or raising that salaries and inflation. But for now, that doesn't matter, even if it were true, because these raises are built in and they'll keep escalating. The nationally, there's the Pregnant Workers Fairness Act. So this is a part of Title VII anti-discrimination. Of course, we don't want to treat men and women differently, and childbirth, treating someone differently based on their carrying or delivering a child is just like sex discrimination. And there's also disabilities are often tied to pregnancy or delivery. Congress passed a Pregnant Workers Fairness Act, and then the EEOC took its time to generate regulations and then comments on the regulations. So we don't have time to cover the more than 400 pages of regulations.
Yeah.
But if you have a pregnant worker, it's worth checking in with if you have a professional HR or an employment lawyer on things like if a worker has a pregnancy related aversion to a smell, if you treat this like a disability, it's like, maybe get over it because it's going to be expensive to get rid of this smell, or we'll look at some accommodation. But now the threshold of whether you need to accommodate a disability, a pregnancy related disability, that threshold has gotten more challenging and riskier for the employer. And so if you have a worker who's pregnant, it's worth either having a professional HR or employment lawyer check in on questions that get raised. Lots of action this year in non-compete agreements. So the Washington's passed and we've got a slide at least for some of this. If we advance 2 slides, Washington was a state that made change to its law through legislation. So we passed a statute making non-compete agreements a little harder to enforce. And then this year, effective June 6th, if we could advance a slide or two, there we have it. Effective June 6th. If you indirectly prohibit a transaction, so some robustly drafted non-solicitations are now going to count as a non-compete under the state statute. If you sometimes lawyers will cleverly draft it instead of calling it a non-compete, they'll say you can't have a transaction with a customer, whether they're you solicited or not. That's going to now be a non-compete for their state statute. The minimum threshold has risen, so 121,000 or so for employees. And if you tie up your independent contractor with a non-compete, now they better be making almost $302,000 for them to be bound by your independent contractor bound by a non-compete. Anyone can sue. And so even if your former employee maybe signs a release or just doesn't sue, the customer who can't work for that person because that person has a non-compete, now that customer can sue if they think the non-compete is unenforceable. If you even offer, whether or not there is a contract, whether or not it's accepted, if you float an offer for them to sign a non-compete that is going to be unenforceable, that can count as violating the statute. You're going to pay $5,000 minimum penalty or actual damages, whichever is greater, plus attorney's fees and costs. You also, if you're familiar with contracts or non-competes, there was the idea that you can't, you need some kind of extra consideration, not just keeping your job to enforce a non-compete. That was the Labriola versus Pilar decision years ago. Now you can't, the word in the statute is leverage a non-compete. So how would that come up? If you use a non-compete that's risky or unenforceable in order to say, instead of this strict non-compete, I'm going to have you sign this more lenient non-compete and use the old one going away as consideration for the new one, that could be considered leveraging the non-compete. Or if you say, don't do business with that one client and then I'll release you for everybody else, that could be leveraging a non-compete, and that's now a violation. There was the FTC, Federal Trade Commission, who passed a regulation, a federal court at the district court level. A district court said nationwide injunction, that's going away. There's some, the FTC is making noises like they're going to appeal and hold on to the regulation. Now that we have a new administration coming into office in January, my prediction is the FTC will change its mind and drop that, and those regulations will go away. That's my prediction, but it's not a zero risk.
A couple of questions from me. Maybe what happens if you have a non-compete, you put it in place 5 years ago, well before June 6th. Now those are all governed by this June 6th. Are there provisions of the statute about pre-existing agreements being governed under this, or what's the applicability there?
Yeah, great question. Under the FTC regs, which probably are 99% aren't going to stick. Under the FTC regs, you're supposed to affirmatively write to everyone who might be in a non-compete with you and
Okay.
tell them it's gone. Under the state statute, which is enforceable, if you wrote it a long time ago, you don't have to affirmatively tell them that it's released, uh, but you shouldn't basically threaten to enforce it unless you're confident it's going to be enforceable, because that could be seen as leveraging, right?
All right. So it is governed by it, and you just can't. I mean, what's the net impact there? Should you amend, or should you just ignore it, and or because since you can't enforce it now, it's just out there.
I in most situations, I think I would recommend getting a new one. And we might have to offer some incentive, some new considerations, so we're not leveraging the old one
Mm.
to give you certainty, right? I mean, I think what the business wants is I want certainty. Are you in or are you not in this non-compete? And what the design of the statute, I think the intent of the statute is the worker also has some certainty. Am I bound by this non-compete or not? And so if you leave it alone and don't change it, one thing that could happen is your worker affirmatively sues you and asks the court to declare, is this non-compete enforceable or not?
And that $5,000 is just a minimum. It could be a higher damage amount, obviously.
Yeah, that's kind of a floor, not a ceiling.
Yeah. And then finally, the 301,000 for some independent contractors. Does that seem like something that's state of Washington driven, given we have such a high, they just know Microsoft and, Amazon and have so many independent contractors, or do you think that that's a federal thing because that's a nationwide issue?
Well, the 301,000 for an independent contractor, that's in the state statute.
Yeah,
Uh,
that's why I'm asking. Is that because do you think like Oregon also has a $301,000 independent, or do you have any idea? I mean, it's kind of an interesting, it's such a random number and it's very high.
it is a random number. The randomness is when they passed the statute, I think it was 100 and 200.
Okay.
So it's double.
Okay.
And then the escalators keep raising it to these random numbers.
Okay. Great.
And so you can imagine if I'm a permatemp at Microsoft, and then I'm bound by a non-compete with um,
Yeah.
my employer of record, but I'm laboring at Microsoft, and my employer of record, typically what would happen is the employer of record doesn't make me sign a non-compete. They'll make the customer, Microsoft, sign a non-compete, right? And so Microsoft will say, I won't hire your worker without paying the bribe to the temp agency. Um, it's been a few years. It's probably been 10 years since the temp agency would have the worker himself or herself sign the non-compete. It used to
Yeah.
happen. It's phased out, I think.
Interesting. That dynamic is something we've dealt with a bunch over the years, is our contractor clients that do work with on the tech side and hire a
Yeah.
bunch of subs. And that's great to see that dynamic.
Uh,
More about it.
you raised a point I forgot to mention on the Seattle changes.
Mhm.
Um, for there is a ordinance in Seattle. I don't think it was widely publicized, but it's passed a few years ago now. It's effective. The independent contractor protection ordinance. And so the if you're doing business with a solopreneur who does their job for you within the city limits, um, this ordinance applies. How could that happen? I got a job in my business is in Renton, but uh my social media manager is an independent contractor and she lives in Seattle. Like if that's a situation that could apply.
Yeah.
If they're a solopreneur, either a single member LLC with no other employees or uh, sole proprietor, um, if there's no one else working in that business, then this ordinance is going to apply. And if it does apply, there's all these restrictions on you. You have to, you got to give them one thing you got to give them is here's all the ways you can sue me if I mess up.
Yeah.
Notice of rights. You have to give them the pre-contract form. Here's how I'm going to pay you. Here's the job. Here's the scope. And then every time you pay them, you have to give them something that looks an awful lot like a pay stub. And then there's anti-retaliation protections. There's, attorney's fees shifting if you mess it up, just like an employee. And so I think what Seattle is trying to do is either kill small business or make hiring independent contractors so painful, you might as well just put them on payroll.
Mhm.
And so a pro tip, like you might want to, in your forms, when you
Mhm.
hire a bookkeeper, when you hire a social media manager who's independent of your business, um, have something in your contract that says you won't do any work on my project within the city limits of Seattle or something like that, or a notice provision, right? If you move or if you do a substantial amount of work in Seattle, you have to notify me, right? At least.
Yeah, that's a great practice tip for sure. Yeah,
Uh,
absolutely.
Good news or bad, lawyers are specifically exempted. So you can hire a solopreneur who's a lawyer and take advantage of them.
Always exempting the lawyers, our state legislature. Think of that. Just imagine that.
There was this year in 2024, the federal government, the Department of Justice, and on the next slide, there's a title about it. Uh, the Food and Drug Administration was talking about, oh, look, another slide, which I'll come back to. Um, Sorry, I got out of order there for a second.
No
Uh,
problem.
we're going to reclassify cannabis. I think cannabis is currently a Schedule 3. It's basically treated like heroin. There's no lawful use for it. You can't write a prescription under federal law for it. They were going to reclassify it to basically like Tylenol. So you could buy it over the counter. You can get a prescription. There are legitimate reasons to write a prescription for it. They were signaling this shift. What's the impact for employer on that? The impact for the employer is under existing state law, uh, you don't have to accommodate medical marijuana because the theory is it's illegal under federal law. And so, uh, were the Food and Drug Administration to put these changes into effect, the employer would have to accommodate medical marijuana. The employer would have to figure out if I do testing and there's off-duty use of cannabis, am I still gonna, can I still fire the person for that, or can they just, you know, give me what everyone laughably refers to as the prescription for pot. What do I do about that? So with the change of administration, my prediction is that this change will die. But I don't have a clear indication on this. If I were a betting man, I think there's a better than 50% chance that the next administration will kill this initiative and will maintain the status quo, which is you don't have to accommodate it. Um, but it was
Yeah, the biggest issue that we've seen with cannabis has been, and we represent a number of sort of cannabis retail locations and things like that, so that we don't really have to deal with it there. But is where a business like a construction company, it's people you would definitely not want for safety reasons, to be using cannabis at their place of employment, regardless of any exemption. And what seems to come up from time for us is like, well, how is this going to impact our insurance? And,
and so
because yeah,
you can absolutely do the little push back because it's a safety issue. If it's safety related, maybe accommodating medical marijuana is not a reasonable accommodation. Um, yes, that makes sense, but I think the failure of government and the courts is it's a risk. They're not going to tell you you can. I mean, they're not going to tell you you can in a sense like you won't get sued if you do. They're going to tell you, in theory that works.
Yeah, it's a fine line, and each case requires analysis and then a very, um, scripted response essentially to make sure you're compliant and not tripping over any landmines. And that I'm guessing this is kind of minute to minute. Like, I think this is a focal area, given that gray area, right? So we should see something perhaps next year federally on this, or what are your thoughts on actual
Uh,
changes in legislation?
yeah, it'd be a reclassification by the Food and Drug Administration, and so it can happen at an administrative level. It doesn't need an act of Congress, doesn't need a executive order, but of course the executive, holy smokes, can appoint whoever can get through advice and consent of the Senate to their executive administration. And,
So,
much could be said about that, but not here.
right. So let's go back a slide and cover one that comes up really often, which is the sort of trends and best practices for terminating employees.
Yeah. I mean, again, lots could be said, but
Yeah, yeah,
let me try
in a
to,
nutshell.
in a nutshell, I would say, of course, Washington is an at-will employment state. At will meaning they can quit or they can be fired for any reason or no reason, as long as it's not an illegal reason. What are the illegal reasons? They're all the ones that you would think of, plus the list keeps growing. And then there's the judge-made common law of wrongful termination, violation of public policy, which has the all the it is a little more predictable than roulette, but um, there's some nuance and lack of predictability there. Why do I say that? There's you know some issue about safety. If a PE teacher says, we really ought to put pads on the cinder block wall behind the basketball hoop because the little kids keep slamming into them and into the cinder block and hurting themselves. If you're fired for saying that, there's a case on point that says, no, you can be fired for that. But then if you advanced that case, there's appellate court precedent with a non-obvious outcome. But if you presented that case again today, would you get the same outcome? I mean, the formalist lawyer in me wants to say, yes, I've got precedent, but the pragmatist, I want to say, I'm not sure that precedent is as reliable as it was when it first came out. And so the guiding star, I would say, to bear in mind, not so much what the law is, but to bear in mind as a risk, if the difference between a valid termination and an illegal termination is motive. And how do you get motive? Not I'm right and they're wrong, but ideally so clear, no, plaintiff's lawyer is going to take this case and sue you. You're going to be protected in the sense that they're not going to sue. Or if the government investigates, even the government would say, "Oh, I'm going to leave you alone. I don't believe it." To get the motivation clear from the circumstances at such a high level, I think that's where either professional HR or experienced employment lawyer talking through that situation can be helpful. If you don't have it, you should develop or I've got a checklist of things to consider when you're firing, steps to take. Do they have a firm credit card? When do I turn off their email? A checklist of things to consider.
What kind of firm property do they have in their possession?
Yeah,
What
exactly.
trade secrets do they possess? Yeah, yeah.
100%. And so sometimes the employment lawyer who wants good for you and knows you're probably firing them because of their attitude, probably, right? You're firing
Mhm.
them because they're hired for their resume and fired for their attitude. Um, you want to throw them out the door, and sometimes discretion is the better part of valor, and someone might advise maybe we want to give them a severance, not because they deserve it, but because it's going to help. And a severance agreement can sometimes both soften the landing, take some of the wind out of the sails of the person who would otherwise hate you, and it provides clarity, right? Sets expectations on both sides. Here's what's going to happen. If they have the passwords to your business Facebook, we're going to get those back as a part of this severance agreement, right? Or the key card to get into your office. We're going to just set clear expectations and get that stuff back. And sometimes, um, again, not so much law, but in an advisory capacity, sometimes um, getting sometimes the employee develops a bad attitude because I, as the hiring manager, made a bad hire and I set them up. They're going to fail in this role.
We're a playground hole. Yeah.
And they mistakenly believe their job is to lobby and say what it takes to get a job, where you, as the manager, you're like, even even if it even if they're nice in an interview, I shouldn't put them in this role because they're not right for the role and they're ultimately not going to succeed. They're not going to excel in that role. Sometimes it's my job to say no. And if I get it wrong, do I have, again, not illegal, but maybe a little bit of a moral, or at least for a goodwill's sake, want to give them a little money to make, if you want your enemy to retreat, give them a golden bridge to retreat from.
That's a great point. I think we call that the human element of everything here. And we're talking about this with our clients. It's definitely a situation where it's like, well, what would make you feel a little bit differently and change the dynamic? Well, if you were treated, a little differently, it's not always viewing it from what's best from the employer standpoint. And then I think one of the things we talk about, which is fundamentally basic and is really easy to overlook, is just maintaining all those good business practices, having uh, quarterly, monthly reviews that are documented and emailed out to it's all in writing, all the performance issues. So the best cases that we have where we have to, maybe bring Aaron on to deal with a termination are the ones where the client can say, yep, here's the quarterly and monthly reviews all written out where we identified the very issue for the termination several times and ways that it could be solved. And the employee was, unable or unwilling to make that change. That is, I'm sure, Aaron, you would agree, just kind of like a huge part of the fact pattern, and it's just goes to motive. It's not everything, of course, but it's helpful.
Yeah, some of you have read books or listened to Seth Godin. Seth says uh, advertisements are the tax on a business that's not remarkable, right? If your business was remarkable, you wouldn't have to pay for ads. Maybe um, severance agreements are the tax for managers who don't document their feedback.
That's great. Yeah, that could be the case. Although I think severance agreements, as you know, play such a big role in a number of other factors that don't immediately come to mind when I talk about this with clients. I'm like, well, I think you ought to think about some severance and a severance agreement. And again, I'm sending them off to Aaron or other, they're another employment lawyer, but that what immediately comes to mind is the money. And you mentioned a few things there that are just absolutely could dwarf the money that's involved in a severance payment. I mean, the security of your property, personal, real property that's involved in the business, the trade secrets they may have, and the expectations for how things are going to transpire communication wise at post employment can have such a dramatic economic effect that's so much bigger than any visceral feeling you get from terminating somebody and then paying them to leave said golden bridge.
Yeah.
So I think with that, I would like to get a few of these questions answered before we conclude here. And if anyone else has more questions, be sure to type them in. One we got was, if you make changes to employment agreements, non-competes, can you ask current employees to execute updated agreements as is, or do you need to provide an employee incentive? And I'll let you answer that, Aaron, but
Yeah, I think I would say you got to give them new consideration. What is that? It could be a 25 cent an hour raise. It could be uh I'll give you an extra day off a year, a floating PTO. It could be a raise, a promotion. But I think it needs to be something so that you're not exchanging and leveraging a non-compete that is unenforceable in order to get signature on a new non-compete. And whatever it is you decide to give them, it needs to be something that they say yes to rather than just not signing your non-compete.
that makes sense. We got another question. We're on a little topic here about the rural Washington, and similar to the last one, is the salary of 78,000 seems really high. Is there any indication they're going to change that to, not be affecting rural areas where salaries are typically less and cost of living is less?
No indication. It is on the majority. The majority owns the House, the Senate, the governor's mansion, and they are not at all interested in the 35 other counties. Is that
Focused on the King and Pierce, great, and Snow So,
but seriously, folks, I would say if you want an exempt person, you could pay them. You could have fewer than 52 work weeks, but then you gotta clear the bar for the minimum for a week is one way to do it. Otherwise, you make them non-exempt.
right. And then our last question is this valid if the hiring company is out of state and you are the only employee in Washington state, or would you fall under the company's HQ's state laws? So I think what they're talking about is in the HQ that's out of state. Yeah, and you're the only employee in Washington state.
Right. The statute's pretty clear on this. And so Washington, if you are a Washington-based employee, Washington law is going to apply. And unlike almost every other contract where you can have a choice of law, you can have a venue provision, you can say, we're going to apply the law of Delaware, and you can only sue me in Oklahoma. That works in almost every other contract, and you can't do that in non-competes. It's got to be applying Washington law, litigated in Washington, or it doesn't work.
Makes sense. And then a final. So the Washington state minimum salary, is there any difference for seasonal businesses like hotels? It's not open 365 days a year. Does that affect the annual wage calculation, or is that like what you just said, where maybe you just answered that, where you're truncating?
Right. You can break it down to a weekly minimum salary and then just have them work those weeks. It'll be if you just Google or search, if you Bing Washington minimum salary 2024 or 2025, it'll tell you the minimum salary annualized or by week. And if you're only going to work them 20 weeks a year, you can just pay the minimum per week. That works.
Great. And actually one more that I missed. If an employee has a pre-existing condition, mental or physical, do they need to disclose that to an employer? Or can an employer ask for that to be disclosed as a part of the hiring process or employment policies?
Great question. And so in a couple of parts, um, the duty to accommodate an employee extends to job applicants. And so in the job applicant phase, um, the think of disability accommodation as you are asking for special treatment. That's what an accommodation is. There is a generally applicable rule, and I don't want it to apply to me. I want special treatment. And if what you want is special treatment, then you got to tell the employer, I have this disability, and here's how it impacts the interview process or the job. And so, please accommodate me. Uh, the employer should ask in the application phase before they work for you. Don't ask anything until you're at the job offer stage. And then you're like, are you able to, here's the job description. Are you able to perform the essential functions of this job with or without accommodation? That's the question.
That is a great tip.
Are you able to perform the essential functions of this job with or without accommodation? And their answer could be a yes. Like they don't have to tell you yet what accommodation they'd need. And then once they're an employee, again, it's, if they want special treatment, they can come and ask. In disability accommodations, especially mental health, no good deed goes unpunished. And so it's 99.9% of the time you should never play armchair psychologist and predict what disability you think your employee has and then email your manager about that or ask the employee if they have that condition. That doesn't work. You could ask something like, um, is there a part of your job that you're struggling with, as opposed to, would you like to tell me whether you have a disability? Now let's keep this in common sense. So if your employee comes in a wheelchair, be a human being, and if so you don't have to pretend like you don't see the wheelchair.
This area is so far down the rabbit hole that this is one where I would be calling Aaron to talk about in a specific situation with the facts. So thank you so much, Aaron, for joining us, and thank you everyone for joining us. Again, this is being recorded and it'll be up on our YouTube channel, on our website. If you want to share it with your employees or HR people or your colleagues. And if you want to reach out to us, Aaron's information will be in that email. And of course, ours is available. Thank you again for joining Holmquist and Gardner's Q4 webinar and celebrating this 15th anniversary with us. And happy holidays. Have a great end of the year. Thank you all. And thank you, Aaron.
Great questions. Had a lot of fun months. Thanks a lot.
Thank you. Bye.